Welcome back to Counting to Five, a podcast about the United States Supreme Court. In this episode, we're going to discuss the Court's unanimous June 12th decision in Henson v. Santander Consumer USA, Inc., the first opinion written by the newest Justice, Neil Gorsuch. But first, a quick term update. On Monday, June 12th, the Court issued 4 more decisions, bringing the term's total up to 47 decisions in argued cases. That still leaves 17 more decisions expected by the end of June. The Court is currently scheduled to take the bench to issue opinions only 2 more times, on Monday the 19th and the following Monday the 26th. But even at the busy end of term, the Court rarely issues more than 5 or 6 decisions in a single day, so based on past practice, it's almost certain that the Court will add additional opinion days to its late June calendar. It's also possible that we won't get decisions in all 17 of the outstanding cases. About half of those cases were argued before Justice Gorsuch joined the Court, and it's possible that the remaining justices are divided 4-4 on one or more of them. If this does happen, the Court will most likely set any tie vote cases for re-argument in the fall, allowing Justice Gorsuch to participate and provide a tie-breaking vote. All 4 of Monday's decisions were technically unanimous, although in 2 of them unanimity with respect to the ultimate outcome is accompanied by significant disagreement about the correct way to get there. But the opinion written by Justice Gorsuch, Henson v. Santander Consumer USA, was truly unanimous, with all 9 justices joining a single opinion and no concurrences. Let's take a look at that opinion now. The case asks who qualifies as a debt collector under the Fair Debt Collection Practices Act, or FDCPA, a federal statute that regulates debt collectors and imposes steep penalties for prohibited practices. The facts are straightforward. The plaintiffs in this FDCPA action, including Ricky Henson, who gave the case its name, got car loans from City Financial Auto and later defaulted on the loans. City Financial sold the defaulted loans to Santander Consumer USA. Santander allegedly tried to collect on the debts in a manner that violates the FDCPA, and plaintiffs sued. The question before the Supreme Court is simply stated: is Santander a debt collector under the FDCPA? A debt collector is defined in the statute as someone who regularly collects or attempts to collect debts owed or due another. So the real question is, what does it mean for a debt to be owed or due another? There are some easy cases. When a company is hired to collect on a loan for someone else, that's clearly covered. On the other hand, when a company that originated a loan attempts to collect on its own loan, it's not covered. But what about this case, where Santander purchased the defaulted loans from the originator? After purchasing the loans, the debt is owed and due directly to Santander. But, in a very real sense, Santander is collecting on someone else's loan, and plaintiffs argued that the statute should be construed to cover Santander's actions. So how did the Court go about answering this question? We're going to get down into the details for a minute or two, but bear with me because then we're going to zoom out and look at the bigger picture. The Court began by focusing on the specific language of the statute, and quickly concluded that Santander is not covered. The Court noted that the key language in the debt collector definition, debts owed or due another, doesn't say anything about the loan's origination or how the creditor acquired the debt in question, but is instead focused solely on the ownership of the debt. Santander owns the debt it's collecting on, so they're not debts owed or due another, and therefore Santander is not a debt collector under the statute. This analysis of the precise language of the statute was basically the beginning and the end of the question for the Court, but the opinion goes on to discuss plaintiffs' arguments in more detail. First, plaintiffs argued that the statute's use of the past tense verb owed means that the language covers a debt owed to another at some time in the past. Even if the debt is now owned by Santander, it is also a debt previously owed to City Financial. The Court rejects this as a matter of normal English usage, noting that past participles are routinely used to describe present status. The Court uses the example of a debt owed to Steve, where the only natural reading is that the debt is currently owed to Steve. The Court then notes that the word owed appears in the phrase owed or due. Due clearly refers to the present status of the loan, and it would be awkward to read the words owed and due as referring to different time periods in the phrase owed or due another. The Court also notes that the word owed is used elsewhere in the same statute to refer to current status. The Court then looks beyond the owed or due language and notes that other parts of the statute distinguish between loan originators and current creditors, while the provision at issue makes no such distinction. Next, the Court addressed plaintiffs' argument that because other provisions of the statute exempt individuals who have, quote, obtained certain types of debt from the definition of debt collector, this implies that by default, individuals who obtain debt, that is, debt purchasers like Santander, are covered by the definition. The court responds by examining the meaning of the word obtain and noting that one can obtain a debt without actually owning it, and therefore that these provisions weren't necessarily intended to apply to purchasers. Finally, the court considers an alternate argument that various provisions of the Act effectively divide the world into mutually exclusive categories of creditors and debt collectors, depending on whether a debt was acquired before or after default. Again, the court carefully parses the specific statutory language and holds that the text doesn't require drawing the desired inferences, especially when they conflict with the owed or due another language that the court already explicated. After addressing all of the textual arguments, the court moves on to plaintiffs' policy arguments. Plaintiffs argued that Congress excluded loan originators from the FDCPA's coverage because they faced incentives that would encourage good behavior. Congress didn't specifically mention purchasers of defaulted debt because at the time the Act was passed, 1977, the market for defaulted debt didn't really exist. But these defaulted debt purchasers present the same risks of abusive debt collection practices as the independent debt collectors Congress targeted in the Act. The court quickly rejects this argument. First, by reference to the proper roles of the court and Congress, saying, quote, "While it is of course our job to apply faithfully the law Congress has written, it is never our job to rewrite a constitutionally valid statutory text under the banner of speculation about what Congress might have done had it faced a question that, on everyone's account, it never faced." But the court goes on to suggest that the policy arguments are not necessarily as clear-cut as plaintiffs suggest, noting that the parties and amici, that is, interested non-parties, have presented plausible policy arguments on both sides of the case, but, quote, "These are matters for Congress, not this court, to resolve." The court concluded by noting that the language Congress enacted in 1977 is not necessarily the final word, saying, quote, "It's hardly unknown for new business models to emerge in response to regulation, and for regulation in turn to address new business models." That more or less sums up the reasoning of this relatively short opinion, but there are a few additional points of interest. First, Justice Gorsuch's writing style, which got a lot of praise from his supporters during the confirmation process, is on full display here. The opinion is very readable. It opens with a colloquial and alliterative line. Disruptive dinnertime calls, downright deceit, and more besides drew Congress's eye to the debt collection industry. Gorsuch uses questions to effectively frame the issue in the case, asking, what if you purchase a debt and then try to collect it for yourself? Does that make you a debt collector too? And does the Act treat the debt purchaser more like the repo man or the loan originator? And he also employs rhetorical questions to pull the reader toward his conclusions. Is it really impossible to imagine that reasonable legislators might contend both ways on the question? Even critics of Gorsuch will likely agree that his writing is engaging and admirably straightforward. This is his first opinion, and undoubtedly Gorsuch took some extra effort to put his best foot forward, but it seems likely he will join Justice Kagan and Chief Justice Roberts as one of the court's best legal stylists. Second, what does this opinion tell us about Justice Gorsuch's approach to the law? This opinion shows, unsurprisingly, that when it comes to statutory interpretation, Justice Gorsuch is firmly in the textualist camp. What does this mean? Textualism is an approach to statutory interpretation, championed most prominently by the late Justice Scalia, that emphasizes the primacy of the specific statutory language enacted by Congress over other considerations. Prominent rivals to the textualist school are intentionalists, who argue that judges should look to the specific intentions of the legislators who drafted and passed the legislation in question, purposivists, who argue that a statute should be interpreted in a way that best furthers the statute's purpose, and pragmatists, who argue that judges should seek an interpretation that will lead to the best practical effects going forward. All of these approaches to statutory interpretation, and others, can be found playing a prominent role in contemporary judicial opinions, and each has prominent advocates in legal academia and the federal judiciary. In November 2015, Justice Kagan had a public conversation about statutory interpretation with Harvard Law professor John Manning. Manning, who only 2 weeks ago was announced as the next dean of Harvard Law School, is perhaps the leading theorist of textualism in the legal academy. In that discussion, only a few months before Justice Scalia's unexpected death, Justice Kagan described Justice Scalia's impact on the court's approach to statutory interpretation.
Justice Scalia has taught everybody how to do statutory interpretation differently. And I really do mean pretty much taught everybody. There's that classic phrase that we're all realists now. Well, I think we're all textualists now in a way that just, was not remotely true when Justice Scalia joined the bench. And
even Justice Breyer?
Well, Justice Breyer might be a little bit of an outlier. Might be a little bit. In certain ways, he too starts with the text.
Okay.
Kagan went on to describe the way the court now approaches statutes.
His focus on statutory text, on the idea that, yes, Congress has written something, and your job truly is to read and interpret and that means staring at the words on the page. And, it's actually remarkable to me how different that is than what used to be.
It has become something of a standard practice for judges, including those judges inclined to give great weight to legislative intentions or statutory purposes, to start with the statutory text and traditional tools of textual analysis before allowing other considerations to come into play. Justice Gorsuch's opinion in Henson v. Santander is a thoroughly textualist opinion and employs textualist interpretive tools popularized by Justice Scalia, including the use of dictionary definitions and English usage guides as evidence of language meaning, and the use of so-called canons of construction. Canons of construction are basically judicial rules of thumb for the interpretation of statutes and other legal texts. Many of the canons have ancient pedigrees, and some are still referred to by traditional Latin names, like expressio unius, which deals with the unstated negative implications of texts, or noscitura sociis, which instructs judges on the use of context to interpret ambiguous terms. The canons came under harsh criticism in the early 20th century as manipulable or indeterminate or contradictory, and fell out of favor. Justice Scalia was a key figure in the canon's rehabilitation, culminating in his 2012 treatise on legal interpretation, Reading Law, co-written with Black's Law Dictionary editor Brian Garner, which is organized around explanations of no fewer than 57 canons of construction. Gorsuch's opinion uses a canon referred to in Scalia's treatise as the presumption of consistent usage to demonstrate that the word owed refers to the present, not past status of a debt in the phrase owed or due another. This canon instructs judges that a word or phrase is presumed to bear the same meaning throughout a text. The opinion also concludes with a strong rejection of reliance on Congress's intent or the statute's purpose to override the enacted text. That this is a unanimous opinion, joined by all 9 justices, shows how widely accepted textualism is in current statutory interpretation. Of course, it's easy to overstate this point. The justices clearly viewed this as an easy case from a textualist perspective, and it's certainly not true that the justices are always on the same page, either with respect to the application of textualist principles, or when and if a commitment to textualism should give way to other considerations. But it's a good example of the way textualism often sets the terms of debate on the current court.
Thank you, counsel. The case is submitted.
2 weeks ago, the court issued its first decision in a case in which Justice Gorsuch participated. That was BNSF Railroad Co. v. Terrell, which we discussed in Episode 7 of this podcast. But because Gorsuch's participation in that case was limited to joining an 8-justice majority, it's not particularly revealing about the perspectives he'll bring to the court. This week, we got Gorsuch's first opinion and got our first real taste of his distinctive style and legal approach. But it won't be until we start to see some opinions in divided cases that we can begin to figure out what role Gorsuch will play on this court. Which justices will he find himself most closely aligned with? To what extent will he be willing to stake out solo positions not shared by other justices on the court? In what areas of the law will he influence the way other members of the court think and vote? We may get the first few hints at the answers to these questions in the next few weeks. We're expecting decisions in 8 more cases that Gorsuch participated in, and there's a decent chance he'll have 1 more majority opinion and a possibility of additional concurrences or dissents. And that brings us to the end of Episode 9. Links to resources related to this episode can be found in the show notes at countingto5.com. That's TO and the number 5. If you're interested in learning more about the current state of statutory interpretation, a great place to start is the dialogue between Justice Kagan and Professor Manning, which is linked in the show notes. It's a thoughtful and nuanced conversation that's well worth listening to. You can leave a comment on the show notes post at countingto5.com or on the Counting to 5 Facebook page, tweet at countingto5, or send an email to mike@countingto5.com. You can call and leave questions and comments on the Counting to 5 voicemail line at 774-226-8685. That's 774-2-COUNT-5. Your feedback helps to shape our coverage, and I look forward to hearing from you. If you enjoyed this episode, please subscribe to Counting to 5 to make sure you don't miss future episodes. If Counting to 5 is not available in your podcast app of choice, please let us know and we'll do what we can to get it listed. Please help spread the word about Counting to 5, and if you value what we're doing, please consider supporting this podcast financially. Visit Counting to 5's Patreon page, where you can pledge as little as $1 a month. Every little bit helps. Thank you for listening. This has been Counting to 5.